The Middlesex Beach Association and Bennett Realty are set to enter a third round of mediation. Beach Patrol Chair David Taylor fights to have the board approve a one-time award for a lifeguard. A community member reiterates his plea to be on the legal committee. Board member Steve Larson catches a community member secretly recording a board meeting and threatens to sue over privacy violations. Board member Nancy Glasgow breaks ranks with fellow board member Marty Schechter over the issue of allowing dogs on the beach. And the new incoming president pivots, allowing members to weigh in prior to important decisions. You're watching the MXB Wire. My name is Greg Pichler, and this is your monthly update for Saturday, October 26th, 2019. During her report on legal, Ellen Throop reported that the DMF Associates and the Homeowner Association are scheduled to enter a third round of mediation. Throop reserved the particulars, including the date of the mediation, to executive session. Well, if you're not familiar with the legal matter between DMF Associates and the Middlesex Beach Association, a Norman law firm, a tenant of DMF Associates, filed suit against the Homeowner Association after the association rejected an application for a digital rotating sign. In January of 2018, 1 month later, the DMF Associates joined that lawsuit as a plaintiff against the Homeowners Association. In April of 2018, DMF Associates unilaterally erected a digital sign advertising the Norman law firm, drawing the Homeowners Association to file a counterclaim against DMF Associates and the Norman law firm. Ultimately, both parties, or all the parties, sought summary justice on the other. The matter went before a master in September of 2018, a master with the Sussex County Chancery Court, who ruled partially in favor of the Homeowners Association. Specifically, the court ruled that Norman was to have no standing on the matter going forward. However, the master ruled that the question of whether the sign violates the covenants of the Homeowners Association is a legal question to be decided at trial. The schedule going forward has the depositions starting in November of 2019 and a 3-day trial beginning in September of 2020. That schedule is subject to change at any time. The parties who are now scheduled to meet in mediation are now limited to the DMF Associates and the Middlesex Beach Association. Presumably, Steve Norman will not be in attendance in that mediation. If so, with Norman out of the room, there's a real opportunity for a settlement to be banged out between the parties prior to depositions. Well, why is that important? The Norman law firm has reportedly been underwriting the cost of litigation until his appeals were exhausted. In the second round of negotiation on September 13th, 2018, Norman demanded the Homeowners Association pay him $120,000 in exchange for a full and final release. The quantum of $120,000 suggests that both parties have spent in the neighborhood of $250,000. After combined legal expense of $250,000, the only accomplishment to date was awarded to the Homeowners Association. The Homeowners Association successfully removed Norman as a party on summary justice. However, the Middlesex Beach Association was not successful in getting an order to compel the DMF Associates to remove the rotating digital sign. Judy Bennett, who owns DMF Associates, along with her co-owners, may not wish to follow the example set down by Norman. In fact, given the cost of the balance of the lawsuit facing them, DMF Associates may decide that keeping Norman on as a tenant is just not worth the bill in satisfying his tenant agreement. DMF Associates may opt to terminate their agreement with the tenant and negotiate a settlement where both parties walk away from the lawsuit, each absorbing their own costs. In the case of DMF Associates, their cost to date has been negligible, presuming that Norman's been carrying them. Although no one is privy to the dynamics between Judy Bennett and her associates, nor the true nature of the contractual relationship between DMF Associates and Norman, the Norman law firm, it is possible that Bennett et al. Will not want to sink good money after bad in a frivolous exercise of winning an argument, even one they're probably going to win. The board at the time believed that it was within its rights to treat any sign that changed within a 24-hour period as a, quote, flashing sign. The covenants explicitly prohibit the adoption of flashing signs. So in effect, that vote, which led to the current policy on digital signage, was the critical lapse in reasoning. In effect, the board adopted the result of this vote as the definition of flashing signs and has never moved off this policy. The vote and the minutes to back it up are no substitute for adopted covenants that would otherwise preclude a commercial tenant from erecting a rotating digital sign that changes more frequently than once per 24-hour period. The demands of the board against DMF Associates is clearly a case of executive overreach by the board against a single commercial tenant, the relationship with the Norman law firm notwithstanding. In fact, the existing sign advertising the Norman law firm is not a flashing sign. However, it takes two parties to successfully reach a settlement, and that's where you come in. It's incumbent on all of us, all community members, to write the members of the board and let them know your feelings. Their email address is board@middlesexbeach.org, or if you prefer anonymity, you can write me. The contact information is on the homepage of the website. The Homeowners Association currently pays $14,000 per year for indemnity insurance. After this is all wrapped up and done, the costs are likely to increase. Our contract is ending in 2021, and the longer this matter goes on and the more painful it is, the higher the premiums are going to be for us. It's not inconceivable that we could be paying assessments in the neighborhood of $3,000 starting in 2021. So we need to get on it. Beach Patrol Chair David Taylor called into Margie Sire's cellular phone at 9:56 a.m. or thereabouts to present his report on the beach patrol. Taylor reported that the committee had come to agreement on a bonus structure for the patrol. In addition to seasonal bonuses, Taylor also advocated for gifting a lifeguard a one-time award for 5 years of service. Taylor did not volunteer on the identity of the lifeguard nor the quantum of the gift. Taylor then asked for the board to approve his recommendations, including the one-time award. Well, Steve Larson said he took no issue with the seasonal bonuses, but asked for the opportunity to discuss the non-seasonal award amongst the board in executive session prior to voting to approve the one-time award. Ellen Throop said she anticipated having no issues and no meaningful input on Taylor's recommendations, hinting she was prepared to give Taylor carte blanche approval to award the patrol as he saw fit within reason. Larson mentioned that no standard formula exists to weigh the decision on one-time awards and that the process seems to be ad hoc each season. Larson continued to say that in the absence of a formula, the board would be replicating the decision it had ruled in past seasons. Nancy Glasgow, who sits on the Beach Patrol Committee, reported that David Taylor and Justin, presumably Justin is a lifeguard, are in fact setting down a formula going forward on awarding bonuses amongst the lifeguards. Glasgow said that the process is currently, quote, too subjective, unquote. Taylor emphasized that a compensation package that includes both salaries and performance bonuses are necessary for the homeowners association to remain competitive as an employer. Taylor reported that the Middlesex Beach Association compensation package is amongst the mid-tier when compared to that of other communities. The starting salary of a lifeguard working in Middlesex Beach is currently $15.25 per hour. President Margie Sire asked for the topic to be reserved for executive session and asked if Taylor could rejoin the conversation via teleconference later that day, to which he reluctantly agreed. Sire also asked if Taylor could distribute the financial numbers supporting the recommendations to the members of the board. Personal matters are exactly what should be discussed during executive session, yet the problem here, unrelated to the one-time 5-year service award, is that the portion of the board meetings dedicated to executive session typically run longer than the portion of the board meetings open to the community. Far too much material is reserved for executive session. According to the bylaws of the Homeowners Association, the only matters to be reserved for executive sessions are ones that deal with personnel issues. This heavy bias towards conducting business in executive session is exactly what contributes to an otherwise lack of transparency on the part of the board. Joe Raskowskis reiterated his plea to be on the legal committee at the meeting. Ellen Throop, who on this occasion was well prepared for Raskowskis' complaint, cited that the legal committee was fully staffed and that the committee was not seeking additional members. Raskowskis, not to be deterred, reiterated that the board has acted illegally on a number of decisions, including delegating the approval of building permits to the building committee, and that his participation would be an asset. Raskowskis maintained that according to the bylaws, only the board can approve or disapprove building permit applications and cannot delegate this responsibility to a committee. Margie Sire weighed in, stating that if the committee had to seek approval from the board on building permit applications, that this would extend the approval process by 1 month. Steve Larson weighed in, stating that the board absolutely can delegate decisions to the building committee. However, later in this discussion, Larson admitted that he was not certain that was the case. Regarding the legality of the building committee having the power to approve or disapprove building permit applications, no one, and I mean no one, is going to file a police complaint over a permit application not being approved by a formal board vote. This adherence to policy and procedure would only matter in a civil court of law, should a challenge materialize over the validity of the approval of a building permit. I am dumbfounded as to what circumstances would have to occur for a community member, a resident, a commercial owner, or otherwise, to challenge an approved permit application by the building committee. Over the course of Ellen Throop's report on legal, Steve Larson took note of Joe Raskowskis operating an application on his mobile phone that depicted a tape recorder in operation. Steve Larson then asked Joe Raskowskis whether he was recording the meeting, to which Joe Raskowskis admitted that he was recording the meeting. On the event of his admission, Steve Larson said he would confer with outside counsel to see whether Joe Raskowskis had violated privacy laws. Raskowskis, in his defense, said that he didn't violate any privacy laws, citing he has a right to record his participation in a meeting. The standard convention that deals with digitally recording a private conversation is it is perfectly legal to do so, provided all parties in the private conversation are aware that the conversation is being recorded and they give their consent. Now, the issue here is, one, Raskauskas never made anyone aware in the room that he was recording the meeting. And two, he didn't seek permission from anyone in the room. On the other hand, it could be argued that the board meeting does not qualify as a private conversation. The board meeting is open to any member of the community who wishes to attend. In my opinion, I would like to see these meetings fully transcribed, if for no other reason that I could get people's quotes verbatim as to what they said. In any event, given the escalating costs associated with the in-house matter, DMF Associates versus the Middlesex Beach Association, given the fact that the costs are running over $250,000, the last thing the Homeowners Association needs is yet another costly, frivolous lawsuit against a community member. According to the board minutes of a previous meeting, the board considered allowing dogs on the beach from 8 p.m. to 8 a.m. between a date in May through to a date in September on a trial basis. Steve Larson weighed in, pointing out that there are over 1,000 property owners in the general vicinity surrounding Middlesex Beach, many of which are dog owners. Larson said that should the Homeowners Association allow dogs on the beach, news of that fact will get out, perhaps even through social media. The news alone could draw hundreds of dog owners to the Middlesex Beach private beach. Larson reported that studies suggest that 20% of dog owners or thereabouts fail to pick up after their dogs, though he did not cite the source of this statistic. Larson further said that children are particularly vulnerable to parasitic organisms and disease from canine excrement and urine. Ellen Throop, who chairs the legal committee, weighed in, saying regardless of the correct proportion of dog owners who pick up after their dog, she has never witnessed a single dog owner remove 5 inches of sand under where a dog has urinated. Alex Sella, who chairs the Community Facilities Committee, weighed in, saying that a trial basis has in effect already taken place over the off-season. Further, Sella reported that over the Labor Day weekend, he discovered 3 fresh stools left behind by dog owners at the end of the common walkway at Bridge Road. Marty Schechter, who chairs the Commercial Committee, who is himself a dog owner and who spearheaded bringing the matter to the community for referendum, weighed in, saying the vast majority of dog owners, in fact, do pick up after their dogs, refuting Larson's uncited assertions to the contrary. Although there was some confusion as to what the current rule regarding dogs on the beach is, it is generally accepted that the board has never formally voted to change the rule prohibiting dogs on the beach, and that the board planned to raise the issue with the membership at the next community meeting scheduled for May of 2020. Steve Larson moved to change the rule prohibiting dogs on the beach following the original rule that is currently advertised on signage at each common walkway. Middlesex Beach President Margie Sire proctored a vote on Larson's motion to return to the original rule prohibiting dogs on the beach from a date in May through to a date in September. Steve Larson, Jeff Sella, Alex Sella, Ellen Throop, and Nancy Glasgow voted in favor of Larson's motion to return to the original rule prohibiting dogs on the beach from a date in May through to a date in September. Marty Schechter, Mike O'Mara, and Tristan Kruger voted in opposition to Larson's motion. President Margie Sire abstained. The vote to prohibit dogs on the beach over the summer season was the first such vote I have witnessed where board member Nancy Glasgow and fellow board member Marty Schechter audibly voted in opposition to each other. In fact, as Glasgow voted in favor of returning to the original rules on the issue of dogs on the beach, Glasgow said she was sorry to Schechter. Glasgow's exact words were, quote, "Sorry, Marty," end quote. Well, why does this matter? I have never witnessed a board member apologize to another board member on how they exercise their respective vote. Further, Glasgow has audibly voted in lockstep with Schechter in virtually all motions prior to that particular vote since they began serving on the board in September of 2018. I can't say with 100% confidence that it has never happened. However, in any event, it was extraordinary. In every vote I have witnessed thus far, Glasgow's vote appears to parrot Schechter's vote. In effect, Glasgow, who does not hold a chair position on any committee, is amplifying what appears on the surface to be a personal agenda on the part of Schechter. Although Schechter may have been disappointed in Glasgow's apparent betrayal, he must have been comforted that his neighbor and now fellow board member, Mike O'Mara, voted in lockstep with him on the issue of dogs on the beach. If Schechter is engaging in coalition building to advance a personal agenda, and I'm not saying that he is, he would not be the first board member to do so. In the past, a number of homeowners have served on the board and invited loyalists to also serve on the board to amplify their influence. President Margie Sire wasted little time in changing the format of the board meeting from that of the previous one held on September 21st, 2019. Sire recognized community members during all discussion involving board decisions. The change in policy was a relief for the community members in attendance. 7 community members, in addition to the board members present, were in attendance, including Joe Raskowskis, Carol Tucker Foreman, Rodney Tucker, Jane Switzer, and Paul Bradley, who sits on the legal committee. Despite the change in policy, Carol Tucker Foreman continued her attack on the board that she initiated over the course of the meeting held on September 21st, 2019. Tucker Foreman admonished the board for, quote, actively rejecting, unquote, the contributions of other board members. Tucker Foreman cited Joe Raskowskis as one community member that the board has actively engaging in a campaign of containment. And that's your monthly update for October 26, 2019. I'm your host, Greg Pichler. I am not going to be present for the meeting in November, but if anyone wishes to secretly record the meeting and forward it on to me, I'd be happy to report on it.